And now Bantam, Nadia. Oh, yeah, dear.
Yeah, me Bantemo, Najifa.
Another day. Yeah, and come over Radom level and some ho. I feel the Supreme Court nearby and also a and Pania airway. Minim say be alcohol, dear, no one so and come on a dorsal. And rat, you see what Russia Bejafie. Mammy, how comes and a record your pon chroma and Dr. Kutu, no so handsome, no so honti. And come out why baby dinner. Emunia Peso fan or bit me, I shall see a diamond. But make all man for said Macobia Daroma, the 2 TV and Oman FM. Make Kai will say Greenfield Scientific Herbal Center, Ruta Natural Product Company, Afe Kings Air Appliances, or more than my papa Abejaso, Sankofa Natural Herbs and Spices. Yeah, marine feet say Spanish garlic mixture, and also Ebwa Amania to me, Akoye. Afe Franco Trading Enterprise, phones, the kind of papa, one must share and a free air banner, one and a boy, but answer me, Beshasiano. Christian Council of Ghana, Ene or May in our cabo, more than answer Siho, de Esra, they say, Ome Boy, na ye may on Sayare, one which I say, ye shall see and rap. And they are twice Yami Aduma or China, the Babana. Now, what I see and you saw no, the theme for the program, Oh God, Heal Our Land, yeah, the 2 Chronicles 7:13-14, and AD anymore. Niasro Yankopon say, O Messiah Yasasi Yare, na ensai we are seeing, and no any idea, Eddie can. All right, Mark with Mammy too.
Medasipi, and pay Mammy Chetty Funa. Na Yemo Bia Sosuachi. Say, I'm a tabe fiada. Nti ne mabande no na che se kusie piewia nyame pa wo kira afofida nti no chase ba idi kama gan ni bia afenhia pa e ma ye ho em so menye fa hodie no fie adusia enan ne mebo a onyame ne yedi ne yie ye man kompo enhwe enipa nyame ene ye nia ye modemo de amaye na ye nya asemre bia dodo no ano ana nipa ni bi no ehwe nkuguo fam ana de bia yin ndro ho no no bebi aduro no say odi wani hwe ho no mo a show nkran e ma tu ana mon kese nti we should be positive in our approach
ma me san ko ma chika also wachina ya fofida
wachina me me da ya fofida
okay
nti so wachina no em so wachina bia be ya fofida
da bi afofida no ya de ko nyame ya adoma ya de ko eni me mfa ma yachi
mate se echina ene adwada o de check he
okay to asoma me check
de di kan mentete enema bi emfemfiri ho yewura aye domrevo ananye sa ejebu eja nya makwemu wonu an sisi wade atum ni Facebook yi odi ade akoto honum na de odi koto honum no emra mampani enam na sante bedi etu so de betu dwa sisi ni de osmo besom ye no omo ani so eni ntino omo dia no kwan kama no ono so de betu say now thank you all our God say anyi we kai pa was here de ne kuma enensa Reverend Martin Rinkat. It has got a very fantastic story, but enye na yebeka and intino emunsem ena we ni we no sabe so yiru nsem an yebum
ya de ma menchire wo hwe fa we ni sha fa we ni toso we no fa toso
wo eja no anchire mfi
ha wonya de toso se ya mo enyi biu
eja wa mfa futu ama ba awade ase na beka kire se ya wo kwehwi mate na me ho me so tede
because
and inti sabe yeso yiru nsem an yebum mebrebe nyina chi kwa ba mempene me ni ade no se na odi abeto ho no mo a me free say so mane yesa no ankasa bio na bibia de kotwere a Ghana ni bia ni anigye eso be se ni nua nti ye mane mepem ho no mo a ye mane mo abeye bi ipa dodo wo Ghana nyina dodo sen na etu abeye auditor general nyame ne na di ni ye nti so say now thank you our God dear you should walk the talk now face mestre ene so aka so ni say o yiru nsema na ibum nti wono so ate ase a yentwa so
okay
etomre bia nipa no wo tata ne mebriba eso pa mo hofo a ene so to ne bema e mani nya odokora free baby ensese nkonya sa do no ntie ma no mpim ho de to so bienu eye covid-19 die edi enya nyame adom Radia Dom, any Yura Kufado, His Excellency, modern more, any pennyful account home, one more to me, Argentino, shall be a media bedroom. Now, dear one is a big rumor saying, Yan or Maya, Idika Crania, a drony bee, Yan Yadewa, Meno Cassay, or Mampeni, any Pomidin swap for any pennyful account, or Matrana Monwa, do never come home. Yes, sir, and this will be a momody and Kowubi. And somehow do the Omo can be. Na mama ne nyamo nwa se Yesu kura mpo no mo kire se be Yesu kura no wangu ya wonti bia na conspiracy theory ya wonti bia na Yesu kura wangu e sande be obi timi boss me Yesu obi timi boss say musira me kura so mo sa problem ni bi anything conspiracy theory there ye be koso ati bebre but there can say se wo do nkwa na wo do abusua na sabia son o man no ehia de a nkotodwem so mampani e de ne nkwa to ho ne yire de ne nkwa to ho na be de ache de ne nkwa to ho ne yire de ne nkwa to ho nom yira mama de ne nkwa to ho ne yire de ne nkwa to ho na sa atu eni asofo kukudam ne nyina akọ bi dia eni nsantwerefo a mo so na mo ye kofa ba mo bo mo humode mo so makoye dia ye nyina ye ntiase na ye nkobi wo nkwa e na wade mahwie ni sa no na memra eye appointment committee o man is say
na wan kasa wanya kwan akọ panel
menkoi
okay
me yedudu enra no se me ko enra no me ye busy pa
okay
but mama san council to aso say okọ wo panel ni wi a enkyere se we ni jai fato ho no enkyere se we di tutu na kwa bomodra so be di aduane nya aduane peche o ne no ye vegetables enuaba ene atosode no mani ntimi no munsuo nya bra home ne nya kwan so ye exercise tie nwum a ebua manipadua no etumpon enwum no mebre no ano ehanipadua no ehyehyɛ ye omampani ene mpanifo di aguna kwam sɛ oworo nsa montete montam monhye ayi ode sɛ kramati no ye ni so ne nyina ka ho bi na sɛ daachi bi no ye benyane ne ye se Ghana zero
ya da nyankopon ase
ya da nyame ase
ya nkwa anim
mahwe ni sa no memra appointment o man ne hyehyɛ ye no yewura omampani ena tumi no man se omu oman no the nam se ba akofo nsa so nyame ani katenti no o man ne hyehyɛ na sa ma ho emra na ma ho kwan so otumi yi asoefo ana o man ne hyehyɛ no o de sɛ emra no so asa ma ho kwan sɛ ye yi uwie nso so a o se totowa no ani nti na ne kwan so ara no yempanimfo a omudi ka akọ em se no mo ye aduenu sɛn enum na emu aduenu mienu de na mo se ehun ni asɛm na miensa bi omo keka ne sa ne se kenya hwe menua na no kura mpo no ma me nkyere mu se ebepim se na NDC emfa wo mo communicate bi emmaye no na even minority in parliament had not come out with anything and I have a copy of their statement here then kama atiefu mu se se edu nkatia mo ene sa nkrofo ni bi no so mo mfiri ho no mo ahotopa de so mo nkoma no ntumu a atiefu mfanche mitumira michirisi ya mitusu ntino emama mfo any communique issued at the end of an emergency National Executive Committee meeting of the National Democratic Congress held on Monday, March 1st, 2021. And some of those was it the meeting discussed, among other things, the ongoing vetting of the ministerial nominees and urged the NDC parliamentary caucus to be firm and resolute in their duties on the appointment committee. It urged them to reject insincere apologies rendered by some at the vetting committees and hold them responsible for their actions. Minia, what do we ever to Jano? And Nigeria who say, a year a year saying, and could you fear Dom Kumano, essay. Enipa miensa bi wo mo de wo nyintum na em se ekoye se asi se ya ayi wo nya na reject wo mo but then tesa eno ye the first ayi se wo so ntiase a the second phase ndo se ba parliament it me e dey see ye no unfortunately me ko reduce any TV akese bi nu o mayi mu ekokire mu ena nyame adom e ba ne sa nti ba na o se aja ahwene te empanima ebi nyira ye to so aba enra empanifo ekohye onya na o ye ahanu aduesia num ahanu aduesia num no nyame ncha de ye babo yewura no dom pre ne empanifo eka ho yewura seche mensa bunsu ene yewura afenyoma kensmo o mo ye adwuma pa enra no me ko nam ho no mo ne nuru echi nyira na me so me hwe de ekoso mesre ye party executive eduru bibi sa no yes o mo modern se nipa no kura hu anim a esi o de sen o therefore any more ferry They say don't get ya no ye no. What me call ho. Ya mama we should abandon them. We should abandon them. What you say, your mama didn't say between any woman. Now, I'm not saying Mrasha phone or my new Majuma, and the party not the Moko. A yapa, Minia. So, party in the small war. What you out here, you know, as Antiachim, Nimuja Gumu, Cheche Biasi this year. And then you apply your Ibimau. It won't cast over the Drudianum Kumutima Macadi among Caffo. And your name of so quack a chinchina wagon Magia tomorrow. And then also, ya, he said, you may. Yamin Chadi. One coin on the coin says, Swallow. About to know, Senya a sea a coin. A year, Doctor Usu a free, me am of an impong. I will catch a penny of dead when a Juma. Open a Greek minister. Why ye Jumapa? I'm so we Akobo Debra when your baby. We ye referee your hormone and send a be Akobo Debra. Also, your MPP. You were free, ya Juma papa. No one apart from say, was she a Greek? No, was saying a Ukraini, but no one see Ukraini. Wabojuma, I'm your Niaso. Oh, what you say? Yamiadum, a coino. I also know Hemunchimu, a dunum, rapasi. To Amutu when you have Emunchimu or her Abianami and sa. When you or her Abianami and sa. A yas, so the goo, Chichimua, a dunumi and sa. Or Hamunchimu, a dunumi and sa, Chilipodio Crunsia. And we know, and I say, a nipa or her dunu bacon and Traman, and a bacon so and Trabano. Oba yen nearby a year, Hawa, Kumsen, or no Sunya. Or her adiesia bakwa, Chese, or Hamono, a adiesia, actually per a diasunum. Ya Chese, Nipa or Hanana and Tramano. Yen near could you upon Croman Sosono, when ya or had you nunum, ye no, ye or ham a enchemu, a dianum or tree, actually per adiesia enum. Ya Chese Nipa or Honey Dubaco. And penny for ya don't call in, I mean, out of Codo in America. Woman Nipa, woman ya Juma, Senya is he say, woman ya Juma, or pet or mine elder. And internal see a job editum. Naminia, I desia or see a seer, editum say in his head. And the Ghana, and yes, said ye, a tear of Ghana, and yes, said ye, a tear unida, your coyanim. So Abakaya, Emra to speak abano. A drew baby, you know, a man for the Biani Bray, and I'm a coy and a monk or two, but the woman is say. Nyansa awe party for the trim. Obia ntimi ankodi di mpanimfo bi atem ene adiade. Ye mu bi kura de. Ye babonten ebe kan say yanhwe ye ne de si ba kwa na mienu so a. Sebi ya de a ebedi party nya. Emse Ghana web yensem kan no. Wo agitum emo mu kura so no. Minua wo ade ye news.
Supreme Court enche be call fi say ade a mpanimfo.
Ho hia pa.
Enche cry be call na. Ansa na ye be call na ye reporter ye ne reporter wo Kwaku Steven akwakodi enkobo sabre a yensa kanwe. Yenhwe say the Supreme Court wo enkekan no esitie na yenhwe say the mpanimfo no wo ene yo ene say the centrofo ne ade. Kwaku temenka me mo akwaba. Hello, Kwaku Steven.
Hello, Papa.
Boko there.
Damiado Boko was announced.
Me wo yes, abre what do Supreme Court wo?
It was Supreme Court. Me no ka say to see idea penny for a judge for penny for the free case not to am look at say a lawyer for with them mama petitioner first respondent and after second respondent will be introduced to home at the court. So but I'm found to just say idea the petitioner na kasa former president John Dramani Mahama no kasa be PM wa say and after petitioner no mu akuma and this for no penny for be bring na be PM wa na face so respondent no penny for ahodo na be PM wa say the second respondent me hu your John Bodo na fi MPP penny for ahodo be bring me look at say there say court after case from of course send you him kwano be a judgment so you hear him question the next few minutes the chief justice himself his lordship kwesi eni yeboa a bit ma pass ruling na for you to be the win na abeti for the true and muti o man so
very quick one na for yen switch Supreme Court wo ye ka say the judges sign o matna say wo ho
What me who a judge for and so sana in that I know a judge for no some so lemu the only time my judges no a swift and after change and kono a bra I'm calling for review but me no can say the judge for and so led by his lordship kwesini yeboa I'm motna asem so am be pass judgment but no only no they are ruling a bar a judge for so ni na e dem ruling e ba himself of course ye hwe nim kwesini wa kwesini yeboa be ready a comprehensive judgment so na na pass on ruling the coin no dey and say wa kwesini yeboa and some few minutes no ba be ready am Ghana for na ati bi no ka say dey wa kwesini yeboa asase o kasa
me da say ye fancy ye so ye switch na ya ba be fa live feed no e dey free o kwa Steven a reporter or Supreme Court na ye no edi nkomo no alright Arithmetical be fi me do ase say dem di kan ma wonya ne ntie no we are going straight to the Supreme Court na fi ya kwa kutie ne e free ho ba judges na trans ye ne de ne e wo ho no ya Arithmetical be me da so ba one ma hwe production no e be pin sabre de obi ase me din e de amofa boache ye so na straight away ya ko Supreme Court ya hwe ene ma hodo a e wo ho nti ye nko na fi ye fa feed ne fa free Supreme Court.
In the declaration she made on 9th December 2020 in respect of the presidential election that was held on 7th December 2020. B, a declaration that based on the data contained in the declaration made by Mrs. Jane Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. C, a declaration that the purported declaration made on 9th December 2020 of the results of the presidential election by Mrs. Jane Adokwe-Mensah, chairperson of first respondent, and the returning officer for the presidential election held on 7th December 2020 is unconstitutional, null and void, and of no effect whatsoever. D, an order annulling the declaration of President-elect Instrument 2020 CI 135, dated 9th December 2020, issued under the hand of Mrs. Jane Adokwe-Mensah, chairperson of first respondent, and the returning officer for the presidential election held on 7 December 2020 and gazetted on 10 December 2020. E, an order of injunction restraining the second respondent from holding himself out as president-elect. F, an order of mandatory injunction directing the first respondent to proceed to conduct a second election with petitioner and second respondent as the candidates as required under Article 63, Clause 4 and 5 of the 1992 Constitution. The language in which the first four reliefs A to D were crafted is suggestive that they were directed against the chairperson of the first respondent. However, the petition is not against her personally, but against the first respondent as an institution of state established under the 1982 Constitution. The article and rule under which the petitioner mounted the action are Article 64(1) of the 1992 Constitution and Rule 68A of the Rules of the Supreme Court, CR 16 as amended by CR 74 and CR 99. They provide as follows: 64 Clause 1. The validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of election in respect of which the petition is presented. Rule 68A, despite Rule 45(4), the parties in the petition shall be A, the petitioner as specified in Article 64, Clause 1 of the Constitution, and B, the person declared elected as president and the Electoral Commission, who together shall be the respondents. Though the petitioner is not in substance attacking the validity of the 7th December 2020 presidential elections, but only the declaration made on the 9th of December 2020, the petition is seen by many as a rehash of the presidential election petition of 2012-2013. In that petition, the second respondent herein, then as first petitioner and others, invoke Article 64 Clause 1, purportedly to invalidate the election of the petitioner herein, then as first respondent, as president-elect, as a novelty done in the constitutional history of the Fourth Republic, and Sir JSC prefaced his judgment in that petition in the following words, quote, "The facts surrounding this suit have been fully played out in near epic dimensions before the public. However, there is no way this suit can be seen as a likeness of the numerous cases on various aspects of our 1992 Constitution. Indeed, I venture to say it cannot be compared to any of the cases touching on various aspects of our Constitution by virtue of this peculiar nature and potential effects. Many commentators have rightly described this suit as one posing a test of the structural maturity of our democratic ethos, causing all eyes worldwide to focus, even if only briefly, on our polity to see if and how we can surmount this unquiet challenge. Without doubt, the resolution of this case portends much for the future path of our democratic development." See, end of quote. See in presidential election petition, Akufo-Addo and Bawumia and Akufo-Addo, Bawumia and Obechebelamte, number 4, versus Mahama, Electoral Commission and National Democratic Congress, number 4, 2013, Supreme Court of Ghana Law Report, Special Edition, page 73 at page 151. And Sir JS's description in the petition before the court in 2013 in the above words was apt, as that case remains one of the most important constitutional cases this apex court has determined in our current constitutional dispensation. It is therefore not strange that the attention that greeted the 2012 petition also gripped the instant one before us, thus placing the two seemingly similar cases on the same pedestal. The big question, however, is, are the two cases alike, or do they present similar issues for determination? The answer in both questions is a big no. It is therefore not surprising that the petitioner in his closing address filed on 23rd of February 2021 admitted the similarity in the instant petition and that of 2012-2013. Background to the petition. On the 7th December 2020, the first respondent hearing, the Electoral Commission, which is the constitutional body established under Article 43 of the Constitution 1992 to conduct all elections and referenda in Ghana, conducted parliamentary and presidential elections in all 275 constituencies in the country, which are made up of 38,622 polling stations. The election was conducted under Public Elections Regulations 2020 CI 127. At the close of the exercise, the first respondent, through its chairperson, declared the second respondent, Nana Addo Dankwa Akufo-Addo, who was the presidential candidate of the New Patriotic Party, as the one validly elected as the President of the Republic of Ghana. This declaration was made on the 9th of December 2020, subject to Article 63, Clause 9 of the Constitution 1992 and Regulations 4410 D and 11 of CI 127-2020, an instrument, Declaration of President-elect Instrument 2020 CI 135 was published under the hand of the chairperson of the first respondent to that effect and published in the Gazette on 10 December 2020. The instrument reads, quote, "In exercise of the power conferred on the Electoral Commission under Article 63, Clause 9 of the 1992 Constitution, this instrument is hereby made. Nana Addo Dankwa Akufo-Addo, the New Patriotic Party MPP presidential candidate, having in the presidential election held on the 7th of December 2020, pursuant to Article 63, Clause 3 of the Constitution, obtained more than 50% of the total number of valid votes cast, is hereby declared the President-elect of the Republic of Ghana. Given under my hand the 9th day of December 2020, signed Mrs. Jean Mensah, Chairperson of the Electoral Commission." End of quote. Article 63, Clause 9, on whose strength the instrument was made, provides, quote, an instrument which A, is executed under the hand of the chairman of the Electoral Commission and under the seal of the commission, and B, states that the person named in the instrument was declared elected as the president of Ghana at the election of the president, shall be prima facie evidence that the person named was so elected, end of quote. The petitioner filed this petition to challenge the declaration made on the grounds of alleged errors and lack of transparency on the part of the first respondent in the correction of the said errors. The grounds for the petitioner's petition are that the said declaration violated Articles 23, 296A and B and 63(3) of the Constitution 1982, and therefore unconstitutional, null and void, and of no effect whatsoever. These articles of the Constitution mentioned in petitioner's petition are those allegedly violated, for which the petitioner sought the reliefs under paragraphs 3A to F of his petition, which provides, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. 296A, where in this Constitution or in any other law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. 63(3). A person shall not be elected as president of Ghana unless at the presidential election the number of votes cast in his favor is more than 50% of the total number of valid votes cast at the election. End of quote. The petition itself. The petitioner, per his reliefs and grounds, is not challenging the data presented by the first respondent, from which the second respondent's declaration as president-elect was made. As a result of that, he has not presented to the court any figures to contradict the data of the first respondent. Petitioner's case simply is that the figures or data declared by the chairperson of the first respondent as the valid votes cast and those obtained by the two contestants, that is petitioner and second respondent, when computed, do not give the second respondent more than 50% of the said votes to merit her declaration as provided under Article 63, Clause 3 of the 1992 Constitution. The petitioner averred that the declaration was therefore unconstitutional, null and void. The petitioner proceeded further to seek an order to set aside the instrument affirming the declaration, that is CI 135, and a further order to organize a fresh rerun between the petitioner and the second respondent in compliance with Article 63, Clause 4 and 5 of the Constitution 1992. The above constitutional provisions were reproduced under Regulation 14, 1, 2, and 3, Regulation 44, 1, 2, and 3 of CI 127, and they read 63.4, where at a presidential election there are more than two candidates and no candidate obtains the number of percentage of votes specified in clause 3 of this article, a second election shall be held within 21 days after the previous election. 5. The candidates for a presidential election held under clause 4 of this article shall be the two candidates who obtained the two highest numbers of votes at the previous election. End of quote. From the nature of the relief sought in this petition, relief B appears to be the major relief on which the other 5 reliefs, that is A, C, D, E, and F, are buttressed. The success or failure of reliefs A, C, D, E, and F depend on the success or failure of relief B. For purposes of emphasis, we wish to reproduce petitioner's relief B. It reads, a declaration that based on the data contained in the declaration made by Mrs. Jane Adukwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. This relief B, as quoted above, raises an arithmetical question. It cannot be resolved without resorting to some calculations. The first task is to know the data the first respondent presented, which the petitioner was referring to. The data will contain inter alia the total number of votes cast at the election, the total number of valid votes cast, the total number of valid votes cast in favor of the second respondent, and the total number of valid votes cast in favor of the petitioner. A percentage of each of the candidates is then calculated against the total valid votes cast. This is the only way to determine whether or not the second respondent obtained more than 50% of the valid votes cast or not, as the petitioner has challenged. In effect, if the petitioner is able to satisfy this court that the data contained in the declaration made by the chairperson of the first respondent did not give the second respondent more than 50% of the total valid votes cast in the presidential elections on 7 December 2020, then all the other relief sought under A, C, D, E, and F must be granted as a matter of course, as that would mean Article 63, Clause 3 has been violated, thus rendering the said declaration unconstitutional, null, and void. The petitioner, in advancing reason to support his petition, contended that the first respondent effected corrections to its original data as announced on 9th December 2020. The said corrections were null and void, as they do not reflect on the declaration made on 9th December 2020. Again, the first respondent did not indicate when the said corrections were made, and also did not involve the petitioner and his agents when making the corrections. The petitioner attached to his petition a pen drive of the video clip of the declaration made by the chairperson of the first respondent, a copy of CI 135, a copy of a press release issued by the first respondent on 10 December 2020, announcing the errors in the declaration and the corrections made, and a few other documents like summary and spreadsheets. According to the petitioner, the first respondent was not fair to him when he failed to engage his agents and to involve them in the corrections of the errors before the declaration. There was therefore no transparency in the corrections made, making the declaration and CI 135 unconstitutional, null and void, as same constituted a violation of Articles 23, 296A and B, and 63.3 of the 1992 Constitution. It is for this reason that the petitioner sought under Relief D an order annulling CI 135 and a further order directing the first respondent to proceed to conduct a second election between the first two candidates, that is, second respondent and petitioner, as the only candidates as required under Article 63, Clauses 4 and 5 of the 1992 Constitution. Clearly, from the nature of the relief sought in the instant petition, it is not identical with the 2012 presidential election petition. That petition sought to invalidate the presidential election conducted by the Electoral Commission by the annulment of over 4 million votes due to alleged irregularities such as overvoting, lack of signature of presiding officers on some pink sheets, no biometric verification in some of the constituencies. However, in this one, the petitioner is not seeking any such relief. He has not asked for the annulment of any votes cast anywhere during the election, and he has not said that the election was badly conducted. He is only seeking to annul CI 135 and a rerun between the candidates with the two highest number of votes, because the computation of the data presented by the first respondent does not give the second respondent more than 50% of the total valid votes cast. That is why PW1, the General Secretary of the NDC, Mr. Johnson Esedun Ketia, testifying under oath, told the court that they did not come to court to challenge figures, so they brought no figures of their own to this court. According to him, they were judging the chairperson of the first respondent by her own Bible, by which he meant they were judging her by her own data, from which the second respondent was declared president-elect. The first respondent case in answer. The first respondent denied petitioner's claim that from its data as presented in the declaration, the second respondent did not obtain more than 50% of the valid vote cast in presidential elections held on 7 December 2020. The first respondent admitted the petitioner's contention that it initially made mistakes in the figures announced on the 9th of December 2020 during the declaration, but juxtaposing the total number of votes cast in the presidential elections with that of the total number of valid votes cast. However, this error was immediately corrected and the correct figure mentioned in a press release the following day, 10th December 2020, and accordingly published in the official gazette. First respondent contended further that even with the error, the fact that the second respondent obtained more than 50% of the total valid votes cast was not in doubt. The first respondent prayed the court to dismiss petitioner's petition for disclosing no cause of action. The second respondent case in answer. The second respondent also denied petitioner's case and describes him as incompetent and devoid of any substance whatsoever. He was of the view that even though petitioners said no candidate obtained more than 50% of the total valid votes cast and sought a rerun between the two of them, the petitioner did not indicate the number of valid votes or percentage thereof that he should have obtained in the election, or the number of valid votes or percentage thereof that the second respondent should have obtained in the election to support the allegations and request for the rerun. He contended further that the corrections of the errors by the first respondent in her statement on the 9th of December 2020, annexed by the petitioner to her statement in support of the petition, were made within the authority of the first respondent and do not infringe any law. According to second respondent, the corrections effected by the first respondent in his press release of 10 December 2020 provided a proper reckoning of the percentage of votes obtained by the second respondent using the valid votes cast rather than total votes cast, and showed that the second respondent obtained more than 50% of the valid vote cast as required under Article 63(3) of the Constitution. He averred that petitioners' claims are anchored on an innocuous mistake made by the first respondent in interchanging total votes cast for valid votes cast when announcing the various percentages obtained by each candidate on 9 December 2020. Second respondent contended strongly that when the total valid votes cast are used as the yardstick, he would still be outright winner of the election by more than 50% of the votes, even if by statistical projection, the votes of all the 128,018 registered voters in Techima South were to be added to petitioner's votes. The second respondent averred further that if the total number of votes obtained by each candidate in Techima South is factored into the results declared by the first respondent on 9 December 2020, the second respondent's share of the valid votes cast is still well over 51%. In fact, the petitioner has no question in the petition. Second respondent denied allegations of violation of Articles 23 and 296 of the Constitution as misconceived. In the alleged vote pardon and the errors referred to by the petitioner, the second respondent, who denied same, contended that granted the allegations were true, they did not have any effect whatsoever on the result of the election. He said the alleged unconstitutionality of a declaration or gazette notification of an election does not constitute a challenge to the validity of an election of a person as president. He emphatically concluded that the petitioner has neither challenged the conduct of the election itself nor its validity, so his action is not an election petition properly so called and ought to be dismissed in limine. Second respondent served notice of his intention to raise a preliminary objection to the petition on the ground inter alia that the petition did not meet the requirement imposed on the petitioner under Article 64 Clause 1 of the Constitution 1992. He subsequently filed a preliminary objection, as the first respondent also did, for the dismissal of the petition on the ground that it discloses no reasonable course of action in terms of Article 64 Clause 1 of the Constitution 1992. Though both the first and second respondents prayed the court to set down for legal argument their objections in limine to petitioner's objection, the court decided to hear the petition in detail and resolve the preliminary legal objection together with other issues raised by the pleadings of the parties. Issues set down by the court for determination. The court directed each of the parties to file a memorandum of issues for trial. The parties complied and filed issues they considered material for consideration. Out of those issues and the materials contained in the petition and the answers to the petition, This court adopted the following as the real issues arising from the pleadings for determination. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent of the second respondent as president-elect, no candidate obtained more than 50% of the valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. Whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techim South constituency presidential election results. 4. Whether or not the declaration by the first respondent dated 9th December 2020 of the results of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1982 Constitution. And 5. Whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. Mode of trial. Since the rules of this court regulating presidential election petition trials, that is CI 16 as amended by CI 74 and CI 99, has a regimented timetable that include a scheduled date for pre-trial case management protocols, the court adopted the procedure in the High Court Civil Procedure Rules as amended by CI 87 on the filing of witness statements with exhibits, if any. The court accordingly directed the parties to comply by filing witness statements within specified periods. They were also directed to file their written submission for and against the preliminary objection raised to the petition by the respondents. Though the petitioner defaulted initially in the direction to file witness statements and their answer to the legal submissions made by the respondents on the preliminary objection, they later complied when the court admonished them to do so within 24 hours or have their petition determined in accordance with the law. The petitioner, who did not file any witness statement of his own, filed witness statements of two witnesses he intended to rely on to establish his case. The first respondent also filed a witness statement of its chairperson, while the second respondent filed a witness statement through his attorney. Standard of proof, burden of proof, and persuasion. A petition of this nature is a form of civil litigation, and like all civil cases, the standard of proof is one on the balance of probabilities or preponderance of the probabilities. The proof prescribed in civil trials is provided under sections 10, 11, and 12 of the Evidence Act 1975 NRCD 323. These sections on the burden of proof, burden of persuasion, and burden of producing evidence, which apply equally to election petitions, provide us 10.1. For the purpose of this act, the burden of persuasion means the obligation of a party to establish a requisite degree of belief concerning a fact in the mind of the tribunal of fact or the courts. 2. The burden of persuasion may require a party A to raise a reasonable doubt concerning the existence or non-existence of a fact, or B to establish the existence or non-existence of a fact by a preponderance of the probabilities or by proof beyond a reasonable doubt. 11.1. For purpose of this act, the burden of producing evidence means the obligation of a party to introduce sufficient evidence to avoid a ruling on the issue against that party. 12.1. Except as otherwise provided by law, the burden of persuasion requires proof by a preponderance of probabilities. 12.2. Preponderance of probabilities means that that degree of certainty of belief in the mind of the tribunal of fact or the court by which it is convinced that the existence of a fact is more probable than its non-existence. End of quote. As was held by this court per additional JAC in Accra vs. Pega Transport Limited 2010 Supreme Court of Ghana Law Report, page 728 at 736. Quote, it is a basic principle of law on evidence that a party who bears the burden of proof is to produce the required evidence of the facts in issue that has the quality of credibility, short of which his claim may fail. End of quote. See also the case of IE versus Shell Ghana Limited and Fraga Oil Limited, 2017-2020, Supreme Court of Ghana Law Report 721 and 733, where this court, speaking through Benin in JSC, had this to say, quote, it must be pointed out that in every civil trial, all what the law required is proof by preponderance of probabilities. See Section 12 of the Evidence Act 1975 and RCD 323. The amount of evidence required to sustain the standard of proof would depend on the nature of the issue to be resolved. The law does not require that the court cannot rely on the evidence of a single witness in proof of the point in issue. The credibility of the witness and his knowledge of the subject matter are determinant factors. See Amma vs. Hydrofoam Estates Ghana Limited, 2013-2014, to Supreme Court of Ghana Report 1551. Indeed, even the failure by a party himself to give evidence cannot be used against him by the court in assessing his case. This court's decision in Ray Ashaliboche Lance, Ajete Agbosu vs. Kote, 2003-2004, Supreme Court of Ghana Report 420, per Judge Nawu JSC as she then was at page 448, and Amma vs. Hydrofoam Estate Ghana Limited, referred to Supra. In the last case cited, the plaintiff did not testify in the action at all, and only relied on the testimony of the court-appointed witness. Yet he succeeded, and this court considered the process valid, so long as the evidence relied upon was credible and sufficient to discharge evidential burden he assumed. Cases on election petitions in Africa and other common law jurisdictions give credence to the notion that in such cases where a petitioner seeks to annul an election or a declaration pertaining to an election, he bears the legal burden of proof throughout. See Abu Bakr versus Yaaldua, 2009, all FWLR Part 4571, Supreme Court. Odinga versus Uhuru Kenyatta, 2012, petition number 5. Opis versus Reneski, 2012, SCC 55. Biseji versus Museveni, Yoweri Kaguta, and Electoral Commission of Uganda, 2012, UGSC. 2001, Uganda Supreme Court. In the Ugandan case of Besege versus Museveni and Electoral Commission of Uganda, Supra, the Uganda Supreme Court held, quote, the burden of proof in election petitions, as in other civil cases, is settled. It lies on the petitioner to prove his case to the satisfaction of the court. And in the Yaaldua case, the Supreme Court of Nigeria held that the burden is on the petitioner to prove not only non-compliance with the electoral law, but also that the non-compliance affected the results of the election. End of quote. This court adopted the same principle in the first presidential election petition titled Ekufuado, Baumia and Obechebe Lamte versus Mahama and Electoral Commission, number 4, 2013, Supreme Court of Ghana Law Report, Special Edition, page 673. The trial itself, evidence led by petitioner. The petitioner did not testify himself and appointed no attorney to testify on his behalf, but called 3 witnesses in all. They were Mr. Johnson Esiedun Ketia, PW1, Dr. Pesa White, PW2, and Mr. Robert Joseph Mertel Nunu, PW3. Under the law, the petitioner is not bound to testify himself if only he could prove his case through other witnesses or by any other means. See the case of Ray Ashalboche, Lance, Ajete Agbosu, and others, Escote, and others, Supra. We know of no law in the common law jurisdiction, especially in civil trials, that mandates a court to compel a party to testify against his will. The failure of the petitioner to testify himself is therefore not fatal to his cause, as the law permits that. What is required from him by law is for him to call requisite witnesses or put before the court sufficient material as evidence. Initially, the petitioner indicated calling 2 witnesses, so only 2 witness statements were filed on the orders of the court. These witnesses were PW1 and 2. After the 2 witnesses had completed their testimonies through the adoption of their witness statements and cross-examination, the petitioner prayed the court to permit him to call a 3rd and final witness to conclude his case. Though the prayer came at a time the petitioner had not given any prior indication of such an intention, for which counsel for the respondents raised objection to the move, the court obliged him and made an order for a witness statement to be taken from his witness to enable him to testify for the petitioner. The petitioner did so and closed his case with the witness who testified as PW3. Out of these 3 witnesses, the one whose testimony appeared to have some relevance to the issues at stake was Mr. Johnson Esiedun Ketia, PW1. He was, in fact, the star witness of the petitioner. His testimony vividly explained the reasons why the petitioner is in court. As for the other 2 witnesses, that is PW2 and 3, Dr. Kwesi White and Mr. Robert Joseph Metenuno, the little said about their testimonies relative to the issue as take the better. PW2 and PW3 were agents who represented the petitioner in the National Coalition Center dubbed the Strong Room. Their testimonies were based mainly on what allegedly happened in the Strong Room during the final coalition and the fact that they failed to sign the final form of the presidential election scored from 13 because of disagreements they said they had with the chairperson of first respondent and her staff in the Strong Room. They recounted a fanciful tale of how the chairperson refused to heed their complaints on some irregularities they noticed in some of the coalition forms that came from some of the regions. We describe this evidence as fanciful because that's why these alleged protests, they went ahead to verify and certify 13 out of the 16 election regional coalition seats. Their testimony included an account of how the chairperson of the first respondent managed to trick them to leave the Strong Room by sending them on an errand to confer with the petitioner, during which period he declared the result of the presidential election without their participation. While the testimony of PW1 was emphatic that the petitioner is not in court to challenge or compare the figures or data presented by the first respondent with any other figures, the testimonies of PW2 and PW3 were in respect of alleged irregularities in the figures or data on some of the regional coalition forms that they cited in the Strong Room, but which they ultimately signed or certified. Notwithstanding all these allegations of misunderstandings with staff of the first respondent in the Strong Room and the fact that they were absent during the declaration, they did not give any indication as to how these happenings and their absence affected the final results announced by the first respondent. Having signed or certified these forms, the witnesses, particularly PW3, cannot turn around to talk of irregularities in the said forms. Their testimonies would have carried some little weight if the purpose of the petition was to challenge entries made on the coalition forms or summary sheets, but that is not the case. Their testimonies were therefore of no relevance whatsoever to the issues set down for determination, and we found them unworthy for any consideration whatsoever in the settlement of the issues. In fact, regarding the testimonies of PW2 and PW3, if their evidence is to be believed, then they have to blame themselves for abandoning their post at the National Coalition Center at the time the verification and certification of the results were ongoing, and PW3 had then verified and certified 13 regional coalition results out of the 16. The agents of the petitioner were given the opportunity to be in the Strong Room. In addition, the petitioner had 2 additional agents as backup or standby. PW2 and PW3 were not under any obligation to leave the Strong Room under any circumstances. Besides, other presidential candidates had their agents or representatives in the Strong Room, and 8 of them signed from 13. If the petitioner's agent believed that in their absence something untoward happened, the petitioner should have called any of the other agents in the Strong Room to testify in court any infractions that happened in their absence, if any. The law is that when corroborative evidence exists, the law expects a party to call such evidence in proof of his case and not mount the witness box and repeat his amendments on oath. The dictum in Mojalagwe versus Labi, 1959, Ghana Report 190, per Olenuje Ashiden was a still good law. The petitioner's agents were given the opportunity to represent petitioner in the Strong Room, and they decided to leave. They cannot complain now that the declaration was done in their absence. With respect to the duties of party agents or representatives, we refer to the Kenyan case of Amolo Odinga and another versus Independent Electoral and Boundaries Commission and 4 others, number 2 of 20th September 2017, where Indongu SCG opined that once the Constitution gives citizens the right to vote, the freedom to choose and conditions are created for the realization of that right. It is not the business of the court to aid the indolent. If party agents are required to be present, sign statutory form and undertake any other legitimate duty that is imposed upon them, as part of the political process in an election, then they are under obligation to do it. To fail to do so is not only to fail one's party, but also to fail our democracy. The courts must frown upon any such inaction, reluctance, and delay. A candidate or her agent cannot abscond duty from a polling station and then ask the court to overturn the election because of a failure to sign a statutory form. Every party in an election needs to pull their own weight to ensure that the ideals in Article 86 are achieved. That we shall once and for all have simple, accurate, and verifiable, secure, accountable, transparent elections. Again, in the Nigeria case of Atiku Abubakar, the Independent National Electoral Commission, and Buhari, Supra, Mohammed Lawal Garba, JC, stated that it is pertinent to restate that from the evidence of all the witnesses called by the appellant, they admitted that their polling agents signed all the result sheets, and this so voluntarily on the instruction of their party, the first respondent. The implication is therefore obvious, as it would have authenticated the validity of the documents. In other words, the result sheets. The agents in law were all presumed to understand what they appended their signatures thereto. They could not in the circumstance have turned around to deny the contents of their signatures. End of quote. Evidence of PWI. Regard to the first witness, PWI, the government of his evidence as per his witness statement after the court had expunged some portions of same upon objection raised by the respondent is captured in the answers he gave during cross-examination by counsel for the first and second respondents. According to him, the petitioner did not come to court to challenge the validity of the figures or data presented by the chairperson of the first respondent. That is why in his testimony, he did not provide any data to contradict that of the first respondent. His assertion was that the figures initially collated by the chairperson contained errors, which his party, the National NDC, the National Democratic Congress, pointed out in a letter addressed to the chairperson on the 9th of December 2020 before the declaration. However, in effecting corrections to the wrong figures or data, the first respondent did not invite them for their participation, but unilaterally effected the said corrections contrary to Articles 23 and 296A and B of the 1992 Constitution. The question is, what is the legal implication, if any, of first respondent failure to involve the petitioner and his agents in correcting administrative or clerical errors made in the computation or the declaration? Neither the petitioner nor his witnesses mentioned any to us, and we do not find any. The court has held in several cases, including the recent ones of Gregory Afoko versus Attorney General, writ number J1/8/2019, dated 19 June 2019, unreported, and Mayor Ablese and two others versus Attorney General, suit number J1/28/2018, dated 28 November 2018, unreported, that breaches or violations of Article 23 on administrative justice and the exercise discretion under Article 26, the exercise of discretion under Article 296 of the 1992 Constitution by administrative bodies, which includes the first respondent, are not matters for the Supreme Court. These are infractions that the petitioner could have sought redress in the High Court. To quote Mafusam JSC in the Afoko case, Supra, Article 23 of the Constitution deals with administrative actions, and even where a breach of that provision is alleged, the remedy lies in the High Court and not this court. Article 23 is part of Chapter 5 of the 1992 Constitution on Fundamental Human Rights and Freedoms, which by Article 33, 1 and 2 of the Constitution ought to be enforced in the High Court. End of quote. See also Eduse versus Attorney General, 1996-97, Supreme Court of Ghana Law Report, page 1, and Eduse versus Attorney General number 2, 1997-98, Supreme Court of Ghana Law Report 753. On the exercise of discretion under Article 296 and alleged breaches or violations of sin, this court in the Mayor Ablese case, Supra, held per Cote JSC as follows. Throughout the Constitution, discretion has been vested in persons or bodies charged with the responsibility to exercise one power or the other where the discretionary power is not exercised according to law, the recourse by an aggrieved party lies in some other remedy provided for in the Constitution and not an invitation to invoke the original jurisdiction of this court. End of quote. Though the two authorities cited above involve the invocation of the original jurisdiction of this court under Articles 2(1)(b) and 131 of the 1982 Constitution, the same applies to an election petition. The first respondent is an independent body that performs its functions without anybody's directions or assistance. Article 46 is specific about this. It reads, except as provided in this Constitution or any other law not inconsistent with this Constitution, in the performance of its functions, the Electoral Commission shall not be subject to the direction or control of any person or authority. End of quote. There is no dispute that the first respondent complied with Article 296 Clause C when it published the regulations CI 127. By this publication, the first respondent did not breach Clause B of Article 296, as its actions were not capricious and arbitrary. They were regulated by CI 127, and there is no complaint anywhere by the petitioner that the first respondent did not comply with CI 127. If it is the case of anybody that the first respondent violated Articles 23 and 296 in the discharge of his duties, which included the declaration of the presidential results under Article 63 Clause 3 of the 1982 Constitution, the remedy of that person lies in the High Court, because strictly such a complaint cannot be an election petition challenging the validity of the election of the President of Ghana. The respondent case. At the close of the petitioner's case, the respondent decided or elected not to testify at the proceedings. They relied on Order 38, Rule 3E5 of the High Court Civil Procedure Rule CI 47 as amended by CI 87, which the court adopted to regulate the trial in addition to the rules provided under CI 16 as amended by CI 74 and CI 99. The respondents prayed the court to decide the issues before it on the strength of the oral and documentary evidence led by the petitioner through his witnesses. This decision by the respondent, which is not a novelty but accepted as settled practice, attracted strong opposition from counsel for the petitioner, who insisted that the chairperson of the first respondent must be made to testify for her to be cross-examined. All the attempts employed by counsel for the petitioner, which included an attempt to reopen petitioner's case, for him to subpoena the chairperson of the first respondent to testify for him as a witness, and an application to review the court's ruling on respondent's decision not to call evidence, which were all resisted by counsel for the respondents, were dismissed by the courts. You would like to reiterate the point made above that in law, the step taken by the respondents has the sanction of time-honored and settled practice in our